Hi everyone. In this session, we will discuss how to spot intellectual property in a product. Companies they develop new products, but when it comes to protection of the product, there is always a lot of confusion on how to protect, whether it should be done, design should be done, copyright. So in this presentation, I'll try to explain to how to spot intellectual property in a product and then appropriately register in the right legal framework. Most of the times, intellectual property in a product may be in the form of the entire product itself. It may be a process, better process, innovative process, cost effective process to make the same product. So here the innovation is in the form of new process. The innovation could be a combination of software and hardware. It may be a software plus course content. It may be a trademark. uh, Keeping the product same, if the design of a product is innovative, then we must find out what is the best way to protect that aesthetic look and feel of the product. In a product, there may be part of it which is a process, but part of it may be a secret information. One of the most challenging thing to protect as intellectual property is a business model. So most of the times it's very challenging to protect business model because it doesn't fit into patent. Even if you register copyright for it, it's not effective. And the design may not be right framework to protect business models. So there is always a question mark when it comes to protection of business model. If your innovation is in the form of new product, process to make a product, or if it is a combination of software and hardware, then you can think of registering your product in the form of patent. Okay, so patent is the kind of intellectual property which may be good to be registered for product, process, or combination of hardware and software. Patent is granted to new product or new process having industrial use and inventive step. It can be either a new product totally, so entire product is new, or it may be one or more features of a product. Validity of a patent is 20 years. So after 20 years expire, people can use it or third parties can use it without your permission. So after 20 years, patent expires and it is open for public to be used. Patent rights are country specific. Your Indian patent is valid only in India. If you want to have rights in Europe or US, you have to file your application separately in these countries. To give you some examples of the kind of innovations which qualify for patent, like this is picture of a voice prosthesis. So it is a product, new product. So best way to protect such products is the in the form of patent. Then we have camera, digital camera. So it is a new product. If it is novel, then definitely it can be registered as a patent. Then there may be improvement in the process or product. So this picture is of Alexander Fleming, who invented penicillin. So if you search on Google, you'll find that there are lakhs of patents on penicillin. So penicillin was invented in 1929, and after that, there have been lots of improvements in the same product. So it may either be a new product or it may be improvement in the existing product. COVID-19 vaccine, maybe the process to make vaccine is new, maybe shape of the bottle is new, the label on the bottle is a trademark. So that's how, we can decide how to register or how to protect the new product in best possible manner. If you have a software or you have some course content, then the best way to protect this is copyright. So copyright is granted to the works which have skill, judgment, and labor. Copyright registration is not mandatory. Without even registration, you can write C in a circle and copyright notice. But registration has advantage that if somebody is copying it, you can take legal action against them. But otherwise, copyright is not mandatory. It comes into being automatically once the work is complete. So we also say that copyright is inherent in nature. Without registration, also you are like fully authorized to write the legal notice on your product, on your software, course content, videos, movies, documentaries, advertisements, your brochures, articles, website. So copyright notice can be done without that. So there is a Berne Convention, and if you register copyright in one of the member states of Berne Convention, then you automatically have legal protection in all member states of Berne Convention. So this is something very beautiful about copyright law. As of today, Berne Convention has 180 plus countries. So if you register your copyright in India, that registration is valid in all member states of Berne Convention, which means that Indian registration can give you protection in 180 plus countries, which is very good. In fact, it comes out to be very cost effective and easy compared to the way patents are being filed. Zoho CRM. Now it is a CRM, so copyright is probably the best way to protect it. Adobe, Google Chrome. So these are some examples wherein the products or the features may be good to be registered as copyright. Trademark is required to be registered for new product or the name of the company, or it may be for all the new upcoming products in the company or the services also. So name of a business is a trademark. It may be a word mark, logo, or tagline. All three of them, they should be registered as trademark. Like patents, trademark is also country specific, but difference is that trademark is perpetual. Patent is valid for 20 years, but trademark is perpetual. As long as you are paying the renewal fee, the trademark remains. So if you don't pay renewal fee in time, then you may lose rights over your trademark. Some examples of trademark synthesis, binding technologies, Benzit, then Neurasim, med device, INT. Okay, so these are some examples of trademark. If there is innovation in design of the product, then it should be registered as design. We call it as industrial design, or this is also called as design patent. Okay, so design protects only aesthetic look and feel of the product. It doesn't have anything to do with functionality of the product. Validity of a design is 15 years from the date of filing, and after 15 years, the design expires. Some examples of design are like look and feel of a watch, look and feel of the bikes or chairs, so any product for that matter, wherein there is a beautiful design, you can think of registering it in the form of design. We have a design office in Kolkata in India, and design also is country specific. You have to register your design separately in each country wherever you want protection. Secret information, if you have in your process or in your product, then you have to see how to maintain it in the form of trade secret. Trade secret is information which is not available in the public. It should have commercial value, and as a owner you should have taken enough steps to safeguard it. One more requirement to get to call any information as a trade secret is like it should be difficult to reverse engineer your trade secret. If you release a product in the market saying that it has my trade secret, but if a user can reverse engineer, then it is not a strong trade secret. So when you choose to protect your intellectual property as a trade secret, you must do a due diligence properly and find out if your trade secret is easy or difficult to reverse engineer, and based on that you can decide whether to call it a trade secret or not. Trade secret is never registered, so since it is a secret and you can't disclose it, so it cannot be registered. Some of the examples of trade secret are Google AdWord, this algorithm, Krispy Kreme, donuts, Listerine, and you have plenty of other examples of trade secret like KFC chicken recipe, Coca-Cola, McDonald's aloo tikki. Business model is usually very difficult to protect in the form of intellectual property, and there is always a question mark on how to protect the business model. So, in my personal opinion, the one of the ways you can protect your business model is establish the fact that you are the first comer. You have very innovative business model. Part of it may be kept as trade secret, and you can establish the fact that you are the first comer to come up with this particular business model. You can do it by having your interviews, by having the publication somewhere. And when you have innovation in business model, you have to be a very fast mover, because in no time there will be others copying your business model. So you should market yourself, or you should have advertisements in such a way that everyone knows that you are the first one to build this business model. And as I told you, that in getting business, you have to be really quick and fast before others copy your business model. You should establish yourself very well in the industry. You have to be creative enough to find out how to safeguard your business model. Okay, so here you can have guidelines, you can have policies, you can have contracts, but you have to have your ways to maintain, privacy, or ways to maintain integrity of business model properly. And you have to be fast mover in the market, like Amazon e-commerce business model. Then you have Airbnb, Oyo. They are very similar to each other, if you really ask me. Swiggy, Zomato. But you have to fast move. And one product may have multiple intellectual properties. Yulu bikes is one of the examples I feel is, where look and feel of the product Yulu bikes is designed. So the way the product looks, maybe we can call it design and register a design patent for it. Technology running inside lithium battery, and other technologies which are running inside the product may be patent. Then the name Yulu Bikes is a trademark. So this way, one product may have multiple intellectual properties. And I feel now, if you look around and see in your room itself, you'll see the products where the look and feel is also good, functionality is also good, design is also good. So and sometimes brand name is also good. So that way, one product can have multiple intellectual properties, and that's how you have to spot intellectual properties in your product, and holistically protect all of them, so that there is no risk of leakage of intellectual property. So spotting the right intellectual property in a product is the first step to be taken to safeguard your innovations. Writing down all innovative components in comparison with existing literature or the products available in the market, it could be very helpful. In fact, this exercise is anyways helpful while building the new product. Finally, identification of right legal framework and the countries where you wish to seek protection, depending upon your budget, area of business. It shall be done well in time. Thank you very much for watching this video today. Keep innovating, keep growing. Good day.